Hello, I'm Dr Annalene Weston, Dentolegal Consultant at Dental Protection. Welcome to RiskBites, a series of podcasts created specifically for dental practitioners in Australia. RiskBites looks at the key dental legal risks and issues affecting dental practitioners across Australia and provides helpful advice and guidance on how to steer clear of them, leaving you free to provide safe and high-quality dental care for your patients. In this edition, my colleague Helen Harbour, who is Dental Protection Australia's in-house lawyer, and I will be talking about what practitioners should do if we receive a request from a lawyer asking us to prepare a report. Most of us tend to experience a mild sense of dread and perhaps even a little panic anytime we receive such a letter, or any letter really, from a lawyer. But Helen, do we really need to get so concerned about a request for a report?
Hi, Annalene. First off, please allow me to clarify what I mean by a request for a report. I'm not referring to a notification of a claim or even a request for records in relation to care you provided. Specifically, what I mean is a letter of request from a lawyer for you to provide information about the treatment for your patient because it relates to a separate claim against another party. So therefore, I can assure you and our listeners that it's certainly not something to be concerned about when a lawyer requests a report from a treating practitioner in this context. If a report is being requested from you, there is absolutely no need to worry that you are in any trouble or that your treatment is under any scrutiny at all. A lawyer wouldn't and can't request a report from you if there was any question about the standard of the treatment that you have provided.
Well, that's certainly very reassuring. So why, Helen, then do lawyers want a report from dental practitioners if there's no issue with the treatment that they've provided to the patient?
Well, lawyers commonly request reports from treating practitioners to have the practitioner provide information and clarity regarding the treatment they provided to that patient in order to assist the lawyer to gather evidence for a separate legal claim against another party.
Okay, so that makes sense then. So what sort of legal claims might a report from a treating dental practitioner be relevant?
Well, there are a range of matters the report might be relevant, Annalene. Some of the common examples would be criminal matters, such as assault or domestic violence involving the face, a motor vehicle accident, a workplace accident, basically any claim which has resulted in an injury to the face or mouth.
So can a report a practitioner writes be used as legal evidence then?
Yes, it can. So before jumping in, there's a few important things to consider before you start preparing the report. Firstly, you will need to know a bit about what the patient's legal claim is actually about so that you can understand the context in which your treatment of the patient is relevant and to enable you to determine the information that's likely to be most beneficial to be included in your report. Most letters from a lawyer will state the subject heading and or in the first sentence that they are acting for the patient in relation to a particular matter. So that might give you some information to start with. For example, there is no point focusing a lot of detail in your discussion in the report about the management of a patient's third molars if the report is really in relation to the trauma to anterior teeth.
So what if they don't provide any detail on the nature of the matter, Helen?
If the lawyer's letter doesn't provide enough information for you to understand the relevance that your treatment has to their claim, don't be afraid to call or email the lawyer directly and just ask for more information that will enable you to write a meaningful report and relevant report. We recently had a member that was subpoenaed by the police to provide evidence in relation to an assault charge where the patient had also been involved in a car accident. The member was asked to comment on whether the dental injuries that he had treated were more consistent with the assault or with the car accident. In order for him to be able to answer that question with any degree of confidence, the member genuinely needed to understand some of the circumstances surrounding both the assault and the car accident.
Yeah, that makes sense, Helen. So it's fine for a practitioner in this instant to contact the lawyer directly or the police directly if they had questions about the request.
Absolutely, Annalene. They're not involved in the claim, only as the expert, as a treating expert, so they should not be afraid to do so at all.
Yeah, that's reassuring because, of course, there are situations where we tell people not to contact
Correct.
the lawyer.
So I can imagine that it's a little bit confusing, but in this case, they're not the defendant or the person being complained about. So it's fine.
Yeah, so they need to understand enough about the background of the matter. And once they've done that, how do they then know what the lawyers actually want them to write about?
Well, the lawyer's request for the report should always set out either a question or a number of questions that they want the practitioner to answer. Bear in mind that good lawyers are wordsmiths, so they are usually very selective and deliberate about the words that they use. So my advice to practitioners is to read the questions set out by the lawyer very carefully, as this will guide you in relation to what they specifically want you to write about and will help you set the focus for your report. However, it's important also for the practitioner to remember that you are ultimately considered the expert on the treatment that you provided. So you are the author of your report, not the lawyer. There may be times when lawyers have a specific agenda that they are trying to pursue, or alternatively, maybe times when the patient has not been 100% truthful with their lawyer about the circumstances of the matter. So the lawyer may be acting on incorrect information. So it's important to just bear that in mind. You might find that to simply answer the specific question or questions that have been asked of you may not provide the full and correct context about the particular aspect of the treatment. If a lawyer has asked a particular question and you consider there's further information which should be provided to properly illuminate the issue, then you should also include that further information that you consider relevant.
Thanks, Helen. So say then that the practitioner has written a report and the lawyers decide they do want to use their report as evidence in a legal claim. What should the practitioner be prepared for or be mindful of?
That's a good question, Annalene. Well, thankfully, these days, very few claims actually do proceed to a full trial before a judge. However, a practitioner preparing a report must always do so with the expectation that it will proceed to a trial. What I mean by that is it's very important to ensure that the report is completely truthful and accurate to the best of the practitioner's knowledge and or experience, as they may very well be asked to confirm their opinion before a judge and be cross-examined about it. In the rare cases when a legal claim does proceed to a trial, it can often be a year or two or even later after you've provided your report and long forgotten about the matter that you might be subpoenaed to give evidence in the trial. Therefore, it's very important that you use language in your report that is very clear to express your actual state of knowledge and opinion about the matter. For example, if you don't recall something from your direct memory, but you are relying on your clinical notes to comment on a particular issue, I would say something like, based on a review of my clinical notes, I can confirm that XYZ. If you cannot be certain of something that you have been asked to comment on, but you can provide an opinion based on your experience, I would say something like, I cannot be certain about whether XYZ. However, based on a combination of my clinical notes and my experience, my opinion is that it is more likely than not that XYZ, or something to that effect. Using very clear language will assist all parties involved, but most importantly, will help you, the practitioner, with your own recall of your opinion, potentially years down the track if necessary. Also, I would recommend they just stick to the objective facts of the matter as much as possible and not speculate.
Yeah, because it can be really easy sometimes for a patient or a third party like a lawyer to try and pressure practitioners into saying certain things because it suits what they want to hear or it suits their outcome, doesn't it?
Absolutely, Annalene. Yes, it happens a lot.
And sometimes they've been a patient for a really long time and it can be hard not to do what they want, but ultimately you're responsible for that report, aren't you?
Absolutely. You're the author, not the lawyer.
Yeah, for sure. So another thing we get asked about a lot, Helen, is whether we can charge for producing a report. Now, can you give any general advice to our members on that?
Yeah, absolutely, Annalene. It is absolutely acceptable to charge a reasonable fee for your time for preparing the report. That's evidence that they're going to use in their matter. My advice is just to charge a reasonable amount. A reasonable fee would be based on the amount of time that it took you to prepare the report.
Yeah, your hourly rate can be helpful with that, of course, but some advice and guidance that we give is it's an hourly rate for administrative tasks, not an hourly rate for your highest level production of dental practice.
Correct.
But it's a helpful guide.
Yeah.
And that's really helpful advice. Thanks, Helen. So do you have any last tips for our members in terms of preparing a report?
Yeah, I'd just like to stress that practitioners should remember that the role of an expert witness, which is what you are if you're requested to write a report as a treating practitioner, is to provide relevant and impartial evidence in your area of expertise to assist the court in reaching its decision. The lawyer's letter or request is a guide for your report, but don't allow the lawyers to dictate your report and especially not your opinion. You're the author of your report, not the lawyers.
Yeah, and your opinion, it's not about right or wrong, is it? It's providing the information because you are not the decision maker.
Correct.
So thanks, Helen. And if any of our members receive a request to prepare a report and would like some assistance, please do give us a call and we can walk you through and give you some guidance. We do hope this podcast was helpful to you and we look forward to sharing more guidance with you in the future. If you like Dental Protection podcasts and you'd like to hear more, please subscribe and leave a review.